Testing 1 2 3, testing 1 2 3. This is Radio Free Mormon on the air, broadcasting behind enemy lines. Tonight's episode, Jenn Kamp loses defamation case. Yes, she has completely lost the case. The case is over. The judge has signed an order that terminates the case. It's called in Utah terminating sanctions. The sanctions have been leveled by the judge, Judge Faust, the son of former First Presidency member James E. Faust of the Church of Jesus Christ of Latter-day Saints. His son, who is a judge in Utah, Judge Faust, just issued terminating sanctions against Jenn Kamp, the defendant in the defamation case that was brought against her by John Dehlin and the Open Stories Foundation. I'm going to be reading that order tonight and explaining anything that I think might be a little bit confusing or need explanation. Also, there are exhibits, actual evidence that go along with the order that I will be going to in a few instances. There are actually 27 exhibits, some of them quite lengthy, to this order. And I'm just going to look at 3 of them for the sake of brevity. Also, because the order does a very good job of talking about the situation anyway and explaining what it is that's going on. So let's go to this right now. By the way, this was signed yesterday, May 15th, 2024, by Judge Robert Faust. You can see it in the upper right-hand corner there at 12:25 p.m. and 9 seconds. So that's 25 minutes afternoon, Utah time. He signed this order. Let me go to this order now, and let's look and see what it has to say. So here is the title: Open Stories Foundation and Arizona Liability Company and John Dehlin, an individual plaintiff, versus Jennifer Kamp, defendant. Order granting plaintiff's motion for order to show cause. Now, that title might be a little bit misleading unless you know what the order to show cause was about, or the motion to show cause was about. It was about the terminating sanctions. Here we go. In this order signed by Judge Faust yesterday that terminates the case. This case is over without a jury trial, and Jenn Kamp has been found by the judge through this order to have committed defamation against John Dehlin and the Open Stories Foundation. There's only going to be a hearing to decide what the damages are for the defamation that Jenn Kamp committed against John Dehlin and Open Stories Foundation. There's not going to be a jury trial on whether she defamed them, because this order says she has. All right. During the hearing on April 23rd, 2024, remember the hearing that I played for you? I got the audio of that and played it here at Radio Free Mormon. During the hearing on April 23rd, 2024, the court heard arguments on plaintiff's motion for order to show cause. Jennifer Tomchak and Shane Gosdis appeared on behalf of plaintiffs Open Stories Foundation and John Dehlin, collectively OSF. Defendant Jennifer Kamp appeared on her own behalf. The court, after having reviewed plaintiff's motion for order to show cause, defendant's opposition thereto, plaintiff's reply memorandum in support of the motion for order to show cause, and the other pleadings and papers on file with the court, and after being fully advised on the premises, hereby grants plaintiff's motion for order to show cause as follows. Findings of fact. This is where the findings of fact are placed in the order that justify the decision that the court reaches. And this decision, once again, terminating sanctions, it's almost unprecedented. I have heard of it once before, and only from that prior hearing where Judge Faust said he was involved in a case like that before. I've never heard about it. Now, granted, my career's been in criminal trial, not civil. So maybe it's been going on everywhere and I haven't heard about it, but I don't think so. The conduct of the defendant has to be so extreme to qualify for a judge issuing terminating sanctions that it almost never happens, because the judge is going to give somebody, and usually somebody who's pro se as well, every opportunity to figure it out, to get on board with a program, to start obeying the rules, and to start being truthful with the court and the other party. Jenn Kamp never got the message. The memo was being sent. She was not picking up on what the judge was laying down. And that has led to the issuance of this extremely rare order of terminating sanctions against Jenn Kamp. So, findings of fact. Throughout this litigation, Ms. Kamp has engaged in conduct intended to and has disrupted the timely and fair resolution of this case. It is unrebutted that Ms. Kamp's counsel made the strategic choice to wait until 3 weeks before the close of fact discovery until after plaintiffs had nearly exhausted all of their written discovery and one non-business day before Ms. Kamp's deposition to file Ms. Kamp's initial disclosures. In other words, this was so late in the process that it prejudiced the plaintiffs and their ability to depose her, to use their written discovery to ask questions based upon these disclosures that were supposed to be made earlier on. And yet it was a strategic choice on their part, which is now going to come back to bite them. The court nevertheless granted defendant an extension of time to conduct her discovery. So even though Jenn Kamp, when she's represented by counsel, made the strategic choice not to give the information from her side until way late in the process, the court nevertheless granted Ms. Kamp an extension of the time to conduct her discovery. It is further unrebutted that after both issuing a preservation letter on September 15th, 2022, and receiving a preservation letter on October 28th, 2022, by the way, preservation letters are letters sent by one attorney to the other side. And the preservation letter says, you got to preserve the evidence. You can't go deleting evidence. You can't get rid of evidence. Right now, you're on notice that we are going to need this evidence, and you are forbidden from deleting it or hiding it in any way. So what this says here, it is further unrebutted that after both issuing a preservation letter on September 15th, 2022, that's when Jenn Kamp's lawyer at the time issued a preservation letter to John DeLynn and the Open Stories Foundation, and she herself received a preservation letter from OSF's lawyers to her on October 28th, 2022. So even after receiving and sending preservation letters, preservation of evidence letters, in which OSF specifically requested that Ms. Kamp refrain from deleting any of the comments made on her social media posts, Ms. Kamp allowed comments from her October 22nd, 2022 and January 28th, 2023 videos on social media to be deleted. Okay? So she's supposed to preserve this stuff. She's under obligation to preserve this stuff, having not only sent out a preservation letter to OSF, but received one from OSF. She's still letting stuff get deleted, if not deleting it herself. It doesn't make any difference for the analysis whether she deletes it or allows it to be deleted or it's negligently deleted. It's her burden to preserve the evidence, especially after you've gotten a preservation letter. When this spoliation, once again, spoliation is the $5 lawyer word for hiding stuff and lying about it, hiding evidence and lying about it. When this spoliation was first brought to the court's attention, the court did not enter any sanctions based on Ms. Kamp's representation that the deletion was unintentional and outside of her control. So this was her first go, right? This stuff gets deleted. OSF's attorneys have to bring it to the judge's attention. She says, oh, I didn't mean to do it. And the judge says, okay, no sanctions. I guess we'll allow it. This is her first warning. This is her first chance. Unfortunately, she may have been taking the leniency of the judge as permission to continue with the same pattern of conduct. Believe the pattern of Jenn Kamp's conduct. Since that time, and despite being given these additional opportunities to cooperate in the discovery process, Ms. Kamp has continued to interfere with the judicial process, to violate direct orders of the court, and to otherwise fail to comply with her discovery obligations. Next section, Ms. Kamp concealed and withheld evidence. At the hearing, and this I think refers to the April 23rd, 2024 hearing, the audio of which I played. At the hearing and in their briefs, plaintiffs presented persuasive evidence to demonstrate that Ms. Kamp, while being represented by counsel and afterwards, concealed the existence of responsive documents. Responsive documents means that OSF had requested these documents by interrogatories, by requests for production. These documents that she's hiding were responsive. They should have been produced in response to those requests from OSF. That's what that means. So she concealed the existence of responsive documents and communications from plaintiffs and subsequently withheld them, even after being ordered to produce them by the court. Specifically, in their first set of written requests for discovery, plaintiffs requested all communications and recordings Ms. Kamp had with others about plaintiffs since January 1st, 2020, expressly including communications with women who had attended a WOCA Women of a Certain Age Waka, I think they pronounce it Waka, conference with Ms. Kamp. Ms. Kamp was obligated to produce any written or recorded copies of those communications pursuant to the request for productions numbers 1 through 3, to identify in writing any of those communications that were not reflected in the documents pursuant to interrogatories numbers 1 and 2, and to identify any of those communications that had existed but were not available and explain why they were unavailable pursuant to instructions E through F. Plaintiffs also requested that Ms. Kamp produce her account records and identify any donations that had been made to her related to her social media posts or the comments she had made about plaintiffs. You see, these requests for production, these interrogatories, are designed to try and find out who it is that Jenn Kamp may have been defaming John DeLynn to via the text messages and other communications, and also how much money she's making from this defamation, hence the request for the account records and the identification of any donations. In Ms. Kamp's initial verified responses, verified is underlined because that means they are signed by Jenn Kamp under penalty of perjury. In Ms. Kamp's initial verified responses to written discovery, she did not identify the existence of or produce the text thread she was on with several OSF donors who had attended the WACA conference with her, referred to herein as the WACA group texts. There are texts between members of WACA, or at least some of the members of WACA, relating to this. And we'll look at some of those here in a minute. Or even disclose in response to interrogatories that she had conversations with any of the women on the WACA group text. She was required to do that as well if she did not produce the text, which she did not. She didn't do anything. She was hiding it completely. She didn't want the other party to know about these texts. She didn't want the judge to know about these texts. And this is one of the big problems she got herself into by hiding information, by hiding evidence, and this is called spoliation. Additionally, she did not identify or produce the recording she made with her husband, Jason Kamp, hereinafter called the Jason recording, nor did she disclose the existence of at least 2 other recordings pertinent to this matter. The 2 main things that this order is going to focus on is her spoliation of the women of a certain age group text, as well as her spoliation of the Jason Kamp recording. Ms. Kamp also asserted in response to an interrogatory seeking information about Ms. Kamp's fundraising efforts, this is what she says, from August 1st, 2022 to the present, defendant has received no revenue or services from any source related to defendant's social media posts or dispute with DeLynn and OSF. Highlighted there, bolded, because she's saying, no, she never got any money at all related to her social media posts or her dispute with DeLynn and OSF. That story is going to change later on. During meet and confer efforts, this is where attorneys get together and they try and talk about things, see if they can resolve any issues before having to go to the judge. Judges hate to have attorneys come to them with issues that they can't resolve themselves. Judges are busy enough, and when attorneys come to them for every little thing because they can't agree, it tends to make judges cranky. Attorneys need to work out everything they possibly can, and only if, after the utmost efforts to resolve things, issues related to a case, they can't resolve it, only then should they go to a judge. So a meet and confer meeting is one of these meetings between the attorneys to iron out the issues before and hopefully to avoid going in front of the judge. During meet and confer efforts, plaintiff's counsel highlighted Ms. Kamp's own references to the missing recordings in various social media texts. This was one of the problems. Jenn Kamp is not disclosing these various items. She's keeping them hidden, but she is giving over a bunch of other stuff. And apparently she didn't go through it carefully enough, because some of that stuff that she did give to the other side, to OSF, contains information in it that references the stuff that she's hiding. This is how OSF found out about it, because Jenn Kamp gave them stuff that showed that the stuff she was hiding existed and that it was not being disclosed by Jenn Kamp. So during meet and confer efforts, plaintiff's counsel highlighted Ms. Kamp's own references to the missing recordings in various social media texts, including communications with an OSF donor describing a podcast Ms. Kamp had recorded with her husband earlier that week, responding to the countersuit. So this is how they found out about the podcast that Jenn Kamp did with her husband, and they have a basic idea as to when it happened because she referred to it in a text message with somebody else, and that text message did get disclosed. It was either disclosed by Ms. Kamp or independent investigation by plaintiff's attorneys found it out. Plaintiffs also pointed out to Ms. Kamp that they believe there were additional communications with OSF donors who were present at the WACA conference, and that there were several publicly available comments that Ms. Kamp had not produced that stated that funds were being raised for Ms. Kamp in connection with the alleged defamatory statements and podcasts. Still, Ms. Kamp continued to conceal and withhold such evidence. They know she's got it. OSF knows she has it. They have it in their possession, and they're telling her, look, we know there's more. They're not giving it to her. They're saying, look, we know there's more. You need to give us everything and quit stonewalling. But still, Ms. Kamp continued to conceal and withhold such evidence. That's how they know she's concealing it and withholding it. They've got it. She hasn't given it to them. They know she has it. In her supplemental responses to the request for production, she provided some additional texts and recordings, but still did not produce or identify the WACA group texts or the Jason recording, the one with her husband. In response to the request for production of her bank records identifying funds she had raised through her social media posts and other fundraising efforts, she responded that she had no materials in her possession, custody, or control that are responsive to this request. Well, you have to go to the bank and get them. During meet and confer communications, Ms. Kamp's counsel, in an August 7th, 2023 email, admitted that Ms. Kamp had gotten one $50 donation. Wait a second, I thought Jenn Kamp had said under oath before this that she didn't get any money. But now they're admitting that Ms. Kamp had gotten one $50 donation, but asserted that the donation had nothing to do with the case. Her counsel did not supplement the discovery responses with this information. This donation came from Heather Daybell, an OSF donor who is also a participant in the WACA group texts. Now, all of this is significant because OSF is bringing a defamation suit against Jenn Kamp. They have to show not only that Jenn Kamp defamed John DeLynn and OSF, but also that she was making money off of this defamation, hurting not only OSF's income by taking donors away, but getting money from those donors who had originally been OSF donors and making them Jenn Kamp donors. This is why all of this is important in this case, and why it's important to include that this donation came from Heather Daybell, an OSF donor who was also a participant in the WACA group text, that one that Jenn Kamp will not give up, remember? On October 1st, 2023, plaintiffs filed statements of discovery issues. Once again, statement of discovery issues is, we are having trouble here with this discovery because the other side is not giving us what we want. We've had a meet and confer with them. We've told them what we need. They have said, we're not going to give it to you. And so we have to go to the judge. So that's the statement of discovery issue, the SODI, S-O-D-I, when you have to go to the judge, have a hearing about these discovery issues. So on October 1st, 2023, plaintiffs filed statement of discovery issues related to the deficient responses to the requests for production and interrogatories. Requests for production, we want documents. Interrogatories, we're asking you questions. We want your answers in writing. They sought to compel complete response to the interrogatories and the production of several items, including the video recordings referenced on specific Bates numbered documents and Ms. Kamp's bank statements. So Bates number just means that certain pages, if you got a bunch of pages together, or even a few, you can Bates stamp them, which is an automatic method of stamping documents with numbers from 1 up to however many pages you have. Okay, that's what Bates numbered documents means. And Ms. Kamp's bank statements, because she hasn't given those yet. They also asked the court to require Ms. Kamp to hire a forensic expert to attempt to recover documents that by then Ms. Kamp had admitted existed but claimed had been spoliated. This included the WACA group text chain and the comments viewers made on Ms. Kamp's posts about plaintiffs. The court granted plaintiffs SODIs, so that's good news, and ordered Ms. Kamp to fully and completely respond to the interrogatories. They should not have to be going to court to get a judge to do this. The interrogatory should be responded to as a matter of course without involving a judge. unless, of course, it's something unusual and you've got a real good reason for not wanting to respond. A legally cognizable reason would be helpful, but that's not the case here. They just have to keep going back to the judge because Jenn Kamp will not comply fully with the request for production. She will not comply fully with the interrogatories. So they went to court, and the court granted the plaintiffs SODIs and ordered Ms. Kamp to fully and completely respond to the interrogatories, to provide the documents requested by plaintiffs, including the videos and the items plaintiffs specifically identified as being referenced by Ms. Kamp in other documents that had not yet been produced. Now, once again, these are other documents the plaintiffs had obtained that were not produced by Jenn Kamp, but that were responsive documents that she should have produced. And I think that this is largely the text thread chain with the Waka group. I think that plaintiffs have managed to get a copy of that somehow, and yet they know it exists, so they know that Jenn Kamp has it because Jenn Kamp is involved in the text thread. And yet Jenn Kamp is not giving it to them in response to their request for documents, which is what they're requesting. So it's an interesting situation where the plaintiffs know she has information she's not giving to them. And so on the basis of that, they're pursuing this and showing not only that she's not being responsive, but also that she's not being honest. And to provide her bank statements within 1 week of its order. She still hasn't provided the bank statements. This is October of 2023. Particularly relevant here, the court warned Ms. Kamp that, quote, the privacy of information is not a valid basis for refusing to provide relevant evidence, period, end of quote. Jenn Kamp had continually said, oh, well, that's private, so I'm not going to give it to you. Oh, well, that's private, so I'm not going to give that to you. Privacy is not a defense. There is no privacy anymore. You're a defendant in a civil defamation suit. You've got to give up information that is requested, that is responsive. You've got to answer questions that have been propounded in the interrogatories, and you have to answer them and provide them fully and completely. You can't say, I don't want to give it to you, and it's private. Not a legally recognizable reason for not responding in a civil suit. The court also specifically instructed Ms. Kamp to seek a protective order if she were concerned about disclosing the contents of her bank statements. Makes sense. There are mechanisms for keeping what would otherwise be potentially sensitive or considered private documents, such as bank statements, away from the public. You get a protection order, only the judge can see it, only the other side can see it, but you have to provide it. And that's how the law responds to the ideas. These items and other items like medical records in other cases might be sensitive, so they can be filed under seal or with a protective order. The court further recognized its concerns about Ms. Kamp's spoliation of evidence, stating, quote, there are questions of whether defendant Jennifer Kamp complied with her preservation obligations. Remember the preservation letters where she's supposed to preserve evidence and not go deleting it or allowing it to be deleted? There are questions about whether she complied with her preservation obligations when, after preservation letters specifically requesting that she maintain copies of her communications and any comments on her social media posts, she deleted or allowed such documents to be deleted. The court ordered Ms. Kamp to retrieve the documents she had been obligated to preserve, provide them, and file a declaration of compliance with the court within 2 weeks of the order, and to produce any videos she had not yet produced within 1 week of the court's order. And I believe this was back in October. Yeah, October 1st of 2023 when all this happened. You see how long this has been going on? This is now May of 2024. That's over half a year ago. And Jenn Kamp has been doing this kind of spoliation since before that, and it's being documented even as far back as October 1st of 2023, and it continues to be documented all along the way because a leopard cannot change its spots, and Jenn Kamp cannot stop hiding and deleting evidence. The next section is titled, Ms. Kamp violated the court's first SODI order. So now that we know what the first SODI order, now that we know what's in the order, we'll see how it is that the judge says she violated those orders. Ms. Kamp, while represented by counsel, failed to comply with the court's first SODI orders described above. She did not produce any of the documents ordered by the court within a week of the orders, nor did she file the required declaration of compliance. Ms. Kamp did provide plaintiffs with a declaration wherein she swore under oath that she had, quote, not deleted any relevant records since receiving the preservation letters, unquote. That she had diligently searched for and produced all responsive documents from her texts, emails, and social media accounts, and that she had accessed and screenshotted all of the comments in her account after receiving the preservation letter. Sounds like she's saying she did everything she was supposed to do. What could be the problem then? Plaintiffs, in their briefing and at the hearing, presented evidence to show that each of these statements were untrue, including that Ms. Kamp did delete items after the September 15th and October 28th, 2022 preservation letters, that she had not produced all of the responsive documents from her accounts, and that Ms. Kamp did not screenshot all of the comments after the October 28th, 2022 preservation letter, because some of the comments she claimed had been deleted were on posts made near to and after October 28th, 2022. Once again, plaintiffs OSF got possession of some things that either Jenn Kamp did not provide them, they got it from another source, or Jenn Kamp did provide documents in which those documents, not being responsive, nevertheless in some places referred to other documents or recordings that would be responsive. Ms. Kamp did eventually produce some documents days after the court-ordered deadline, but notably absent from that production were at least 3 of the video recordings the court had ordered her to produce: the WACA group texts, any document showing Ms. Kamp's efforts to retrieve the WACA group texts, and Ms. Kamp's bank statements. So these are the 3 things, really. I mentioned the JSON recording, the video recordings, 2, the WACA group text thread, and 3, Jenn Kamp's bank statements. Those are the 3 main issues that are going to be the basis for this order, and that Jenn Kamp, for whatever reason, refused to produce. Instead of producing the bank statements and seeking a protective order as instructed by the court, Ms. Kamp produced a heavily redacted Excel spreadsheet that she purported to be her bank statements. That spreadsheet was not a bank statement and was so extensively redacted as to obfuscate any meaningful content, including what account it was providing information about. Okay, now I'm going to go to the exhibit. It's Exhibit G, and I'm going to let you look at these bank statements. This is what Jenn Kamp produced in response to the judge's order that she produce her bank statements to the plaintiffs. Okay, so here's Exhibit G, and let's scroll down and we'll see her bank statements. Now look at this. This is what Jenn Kamp gave to the plaintiffs in response to the judge's order that she give them full and complete bank statements. These are so highly redacted that on this you can only see 3 lines that are not redacted. There is no meaningful information in any of this. There appears to be a dollar amount here, a date, doesn't say who it's from, doesn't say why it's paid, doesn't even say who it's to, doesn't even give any information related to who owns this bank account. And this is pages of this. Here's another one like this. There's a Patreon deposit, Venmo deposit, Patreon deposit, no amounts. Wow, here's one that says a name and then another name down here. It just says a general payment, doesn't have the amount of the payment. And here's another page where it has our truth be told podcast at gmail.com. I don't know what these numbers are. I'm not sure what these numbers are. Maybe these are numbers that represent dollar amounts over on the left, right next to our truth be told podcast. That looks like those could be dollar and cents, but it's not easy to tell. And there's no information about who it's from or when it was given. Here's another page. Look at this. This just has crazy numbers on it. This is what Jenn Kamp provided even after the court said you have to provide unredacted copies of your bank statements. This one doesn't even have any information on it. It just seems to be redacted. Here's another completely redacted with no information on it. Once again, no information here. And that is the end of those documents that Jenn Kamp gave to the other side after they were requested, after the other side talked to her and said, no, you can't do this. You have to give us unredacted copies. After she refused to do that, then they had to go to court and get the judge to order her back in October to produce unredacted copies, which she continually refused to do and still has not to this date, as far as I'm aware. I remember it was a subject at that hearing on April 23rd, 2024. All right, let's go back to the order. There's Exhibit G. We just went through those documents. The redacted spreadsheet also demonstrates Ms. Kamp's misstatements in her earlier discovery responses. It reflects deposits from unidentified sources to unidentified locations on 10/18, 11/14, 12/29, all of 2022, and then 1/9 and 2/4 of 2023, all of which predate Ms. Kamp's initial and supplemental verified discovery responses, in which she claims she had gotten no money and had no records of funds paid to her in connection with her podcast. So she says in a verified statement she'd received no money from the podcast. Then she produces these documents, and even as heavily redacted as they are, the 5 dates that talk about deposits in these highly redacted bank statements, if you can call them bank statements, all of those predate the date that she signed off and verified saying she had received no money from her podcast or social media posts. Appears to be a contradiction. Also, in Ms. Kamp's production of documents was a copy of a comment from a video that Ms. Kamp had not produced or identified in any of her earlier responses to discovery. The comment was made on a podcast titled Reading Public Statements and Counterclaim Against John DeLynn and OSF. It is especially remarkable that Ms. Kamp did not produce this recording earlier, as it was uploaded to YouTube around June 17th, 2023, less than a week before her initial discovery responses were provided. Let me explain this just a bit. First off, moving backward, they're saying, how is it that Jenn Kamp does not produce this recording? She made a recording, a podcast titled Reading Public Statements and Counterclaim Against John DeLynn and OSF. She takes this podcast, uploads it to YouTube around June 7th of 2023, and it was only a week later that her initial discovery responses were provided, in which she does not refer to this, in which she does not provide this recording. So why is she not talking about something when she just did it a week ago? It would be fresh on her mind, and she would know it would be responsive to these questions and these requests for production that are being made by the other side. Now, explaining this other comment, also in Ms. Kamp's production of documents was a copy of a comment from a video that Ms. Kamp had not produced. Remember, Jennifer Kamp is saying, hey, this video, it's private. I'm not going to produce it. You don't have any right to it. It's private. Okay. Once again, not a legally cognizable reason for not providing it. And she ended up being ordered to provide it. Still hasn't provided, as far as I know. She's given a number of excuses as to why she can't. And we'll get into that in a second, too. But she did provide in the documents that she provided, right? Which is a whole bunch of stuff. They winnowed through it. They went through every page, and there was a page that showed a comment on this video, a YouTube comment in the comment section. There was one comment there, which means somebody saw this video. It was not, as Jenn Kamp had told them, that nobody ever saw it, that it was never public, that it was never watched. But no, there's a comment they found that was put in the comment section of the YouTube video. And therefore, OSF knew somebody had obviously seen it if they're leaving a comment. And I want to go to this comment on Exhibit H because it's particularly heartbreaking to me. I mean, this is the craziest comment. It doesn't make any difference what the comment says. It shows that somebody saw it, right? But look at this comment, okay? Here it is right here. You see the title of it, Reading Public Statement and Counterclaim Against John DeLynn, etc. And to the right of that is My Truth Be Told. That was Jenn Kamp's podcast. And here is the comment that was located by Steve 6 a.m. I was going to pay for my medical treatment, but now that I know you took a second mortgage out, I want to help you instead. What is the best way to give you funds? Isn't that heartbreaking? Here's a guy, he's going to get medical treatment, but he hears in this podcast that Jenn Kamp did that she's taken a second mortgage out on her house. Obviously, that was in the podcast. We don't have the podcast. We have this comment from a guy who did listen to it and left a comment. Thank you, Steve 6 a.m., for leaving that comment, because that was the key that proved that no, this had not been kept private. It had been shown to at least one other person, Steve 6 a.m., if not others. And the proof of that is in the comment that was left by Steve 6 a.m. Thanks, Steve. Okay, now having gone through all that, I'm going to read paragraph 22 again. I think it'll make more sense. Also, in Ms. Kamp's production of documents was a copy of a comment from a video that Ms. Kamp had not produced or identified in any of her earlier responses to discovery. The comment was made on a podcast titled Reading Public Statement and Counterclaim Against John DeLynn and OSF. It is especially remarkable that Ms. Kamp did not produce this recording earlier, as it was uploaded to YouTube around June 17th, 2023, less than a week before her initial discovery responses were provided. Okay. So now you can see the kind of shenanigans that Jenn Kamp was up to and has been up to for many, many months, and why it is that she just got terminating sanctions issued against her by Judge Faust. When Ms. Kamp was later asked why she had not produced the video itself, Ms. Kamp claimed that she was withholding it on the basis of privacy, claiming that because she had never shown it to anyone, what about Steve 6 a.m.? Because she had never shown it to anyone, she did not have to produce it. In addition to being in violation of the court's specific ruling in its October 12, 2023 order that privacy is not a valid basis for withholding documents, her position was contradicted by the comment on the post. This comment proved that the recording had been published to third parties and indicated that Kamp was indeed monetizing the statements she was making about plaintiffs. Plaintiffs engaged in meet and confer efforts, again, regarding the missing documents and the sufficiency of the heavily redacted spreadsheet that Ms. Kamp claimed was her bank statement. They also continued efforts to receive the requested documents by asking for them using oral requests at Ms. Kamp's deposition and with follow-up emails to her counsel. Now, this kind of paragraph is written especially for the judge, so that the judge knows that the attorneys for the plaintiffs really have been trying to work on this, to get discovery in avenues that don't involve coming to the court and bothering the judge about it. They've been doing their best. They've been doing everything that they can do as attorneys, but they're still being improperly denied this information. When plaintiffs' oral requests and follow-up emails remained unanswered, they used their last requests for production. Good idea to save a few in case you need them in a case like this, because your number is limited when it comes to requests for production or the number of different requests you can make for different documents to the other party. They used their last request for production to specifically request 3 videos. The video titled Reading Public Statements and Counterclaim Against John DeLynn, the 6-hour podcast, and the Jason recording. Additionally, plaintiffs requested the missing WACA group texts along with other specific documents referenced in Ms. Kamp's produced documents and deposition testimony. They also continued their efforts to get Ms. Kamp to voluntarily produce the account records and bank statements that Ms. Kamp had been previously ordered to produce in October. So OSF's attorneys are doing everything humanly possible here, and they still are getting nothing responsive from Jenn Kamp's side. Once again, in response to the second request for discovery, Ms. Kamp did not produce the 3 recordings. So, second request for discovery, they used their last 3 to request those 3 recordings. She still doesn't produce the 3 recordings. She doesn't produce the WACA group text. She doesn't produce the account records, and she doesn't produce some of the other requested documents. In her responses and objections, she claimed that all of the 3 recordings were private, and she did not have an obligation to produce them. Wrong, and wrong on all 3 of those recordings, Jen. It was only after OSF sent an email to Ms. Kamp with proof. The comment reflected in Exhibit H. That's the one from Steve 6 a.m. It was only after OSF sent an email to Ms. Kamp with proof that the reading public statements, that video, had been publicly disseminated, undermining her claim about the recording's privacy, that Ms. Kamp finally produced the reading public statements video on January 24th, 2024, after the close of discovery. It was then that plaintiffs were first made aware of the specific accounts to which Ms. Kamp was soliciting funds. The text description accompanying the reading public statements video urged Ms. Kamp's listeners to look at her counterclaim, the counterclaim the court had twice rejected by that time, and to donate funds into 3 specifically identified accounts: Mountain American Credit Union, PayPal, and Venmo. Because Ms. Kamp waited until the end of discovery to disclose this video, remember, she refused to produce it, claiming that nobody had ever seen it until after the plaintiff showed her the comment that shows that actually somebody had seen it. It wasn't completely private. Then she produced the video. It was very late in the game. Because Ms. Kamp waited until the end of discovery to disclose this video, plaintiffs were deprived of their opportunity to conduct any discovery relating to the video, including deposing Ms. Kamp about the video and subpoenaing the financial institutions to which she solicited funds. A few days later, during the meet and confer meeting for the second request for discovery, Ms. Kamp claimed that she had no obligation to produce the remaining two recordings because they were private, in that they had never been published, and claimed that she had produced all of the bank records, referencing only the redacted Excel spreadsheet from an unidentified account. The ones I showed you, the ones in the exhibit. That's all she's ever produced, and yet she claims that she's produced all of the bank records. Plaintiffs pointed out that privacy was not a valid excuse for withholding relevant and responsive documents, and that they were entitled to test the veracity of her claims since she had previously inaccurately claimed she had not published the Reading Public Statements video. Ms. Kamp persisted in her refusal to disclose the other two recordings, despite the court's earlier order to produce them, and its warning, the court's warning that privacy was not a valid excuse for withholding evidence. Plaintiffs then filed a second statement of discovery issues related to their second request for production. So they're having to have these meet and confers. They're having to have statement of discovery issues. They're having to file them. They're having to argue them. And they're having to have the judge issue orders, which Jenn Kamp then ignores and violates. And so they have to go back to court again. This has been going on since October of last year. This is what ends up resulting in the order that was issued on May 15th, 2024, saying this case is over. You have screwed around with this court long enough. You screwed around with discovery long enough, and you have been dishonest to the other side and to the court long enough. We're ending this case now, and we're ending this case with this order. And this case is going to say there's not going to be any jury trial. You, Jenn Kamp, are being held now and ruled upon to have committed defamation against John DeLynn, NOSF, period. You have committed defamation against them. There's not going to be any jury trial on that. That is a decided issue of fact now in the court record because of this order. And now there will be no jury trial, but only a hearing in front of Judge Faust to determine the amount of money that Jenn Kamp is going to have to pay John DeLynn for her defamation. So plaintiffs then filed a second statement of discovery issues related to their second request for production. The second SODI specifically petitioned for a definitive court order compelling the production of the two withheld video recordings, the unredacted bank statements from all of the accounts identified in Ms. Kamp's post, the full Waka Group texts, the remaining withheld items, and for Ms. Kamp to verify her interrogatory responses. In other words, she has to sign at the end saying this is true and these responses are full and complete and accurate under penalty of perjury. That's the verification, so that she can then be later held to those responses, which have to be made under oath, which she did not do, and which they're asking the court to compel her to do. Sign the verification, Jenn. Ms. Kamp opposed the second SODI, again claiming that her recordings were private because she claimed to have never shown them to anyone, that she had already produced the Waka Group texts, that her bank statements had been produced in full. You saw what she produced. This is exactly what it is that Jenn Kamp is saying, that her bank statements have been produced in full, and that she had received $0. That's a quote, received $0 from one podcast and $2,000 from another one. What? She's making more and more money off this all the time. And $2,000 from another one, so that plaintiffs should just trust her that the bank statements would contain no useful evidence. Oh yeah, we're going to trust you on that one, Jenn. Even if these monetary claims were proven true, they contradict her earlier sworn statement, right? That, quote, defendant has received no revenue or services from any source related to defendant's social media posts or dispute with DeLynn and OSF. The court granted plaintiff's second SODI and ordered Ms. Kamp to produce the 6-hour podcast, the JSON recording, her unredacted account statements from at least the 3 identified accounts, the Waka Group texts, and other documents within 10 days of the order, entered on March 8th, 2024. With respect to the bank statements, the court expressly stated that the production, quote, shall include the actual unredacted bank statements and not the heavily redacted Excel spreadsheet from an unidentified source that Ms. Kamp previously produced. She still hasn't obeyed that order. The court also directed Ms. Kamp to file a declaration specifically identifying by Bates number or by attaching the responsive documents to the declaration any documents she claimed to have previously produced that plaintiffs claimed were missing. You see, she's not producing documents, but she's claiming that she is. She's not producing unredacted bank statements, but she claims that she is. You see, she's not producing a complete text thread of the Waka group text, but she claims she is. And so now she's throwing all of this confusion into things by misstating and mischaracterizing what it is that she's given to the other side. And so the court now has to take the extraordinary step of saying he wants Ms. Kamp to file a declaration signed under penalty of perjury, any documents that she claimed that she sent to the plaintiffs, but that the plaintiffs say are missing. The court specifically warned Ms. Kamp that if she did not comply with the court's order by the deadline imposed therein, the court will consider sanctions. Next section. Ms. Kamp violates another court order and continues to withhold documents. Despite that warning, Ms. Kamp still did not produce any bank statements. Further, her declaration did not comply with the court's order as it was not a sworn statement. It made conclusory statements about how and when certain items were produced and failed to identify or attach a number of documents that Ms. Kamp claimed had been produced. With respect to the bank statements Ms. Kamp was twice ordered to produce, Ms. Kamp offered no excuse for her continued refusal to produce them. In her declaration and opposition, she adamantly claimed to have already produced the bank statements. When the court pressed Ms. Kamp at the hearing, the April 23rd hearing, to specifically identify the bank statement she had produced, she referred the court to the heavily redacted Excel spreadsheet she had previously produced that the court explicitly told her in its second SODI order was not sufficient. She also offered no excuse for not producing full statements from the PayPal or Venmo accounts specifically ordered by the court. She could not point to a single actual unredacted bank statement that she produced in response to the court's direct order. Ms. Kamp attempted to argue that she had not made much money from her fundraising efforts, but the court had already ruled on the relevance of these account statements. Moreover, given the multiple times that she has changed her story as to how much money she has raised, the comments from others referring to funds being raised on her behalf, and the other areas where she does not appear to have been forthcoming, it is plaintiff's right to test the veracity of her statements by reviewing the account statements themselves. They would have that right even if she didn't have this long history of obfuscation and mendacity. But that only makes the right more pertinent, I think. In addition to the foregoing violation of the court's second SODI order, Ms. Kamp also produced only one of the recordings the court specifically ordered her to produce. Remember, that was the one they caught her on, where they found the comment, and that so they knew it had been made public, and she gave that one over, but not the other two. The 6-hour video and the Jason recording are the two that she still did not produce and has never produced, to my knowledge. She withheld the Jason recording and admitted at the hearing that she could not produce the full Waka group texts because she, Jenn Kamp, had deleted select messages within that thread and could not retrieve them. Next section, Ms. Kamp spoliated the Jason recording. After engaging in the foregoing efforts to conceal and withhold the Jason recording as described above, Ms. Kamp made a series of contradictory claims about why she violated the court's second SODI order and still was not producing the Jason recording. These contradictory statements persuasively demonstrate that Ms. Kamp intentionally spoliated that recording, likely after the court ordered her to produce it, and that she has not been forthcoming with plaintiffs or the court. So these contradictory claims about what happened to the Jason recording and why she can't produce them, the recording, the podcast she made with her husband, Jason, are in Exhibit W. And we will go there and see what that looks like. And here it is, Exhibit W. So here we go. February 16th, 2023, in a text with Heidi Sharp, Jenn Kamp says, JAS, Jason and I are. Jason and I did one together. So Jason and I did one together. We recorded earlier this week. The text is February 16th, 2023. So the recording was done earlier that week, sometime in mid-February of 2023. So here she admits that they did a recording. On January 30th, 2023, in a meet and confer with OSF's counsel, she said, "I don't even know if my husband and I ever actually recorded that." Well, wait a second. In February 16th, which is actually later, it's a couple of weeks later than this, she's telling somebody else in a private text message, guess not so private, in a private text message that they did record it earlier this week. But 2 weeks earlier than that, she's telling OSF's lawyers, "I don't even know if my husband and I ever actually recorded that." Recorded it. We talked about it. We wrote down things about it. March 18th, 2024, which is now much more recent, in a certificate of service and email to counsel, Jenn Kamp says, "The second podcast was never recorded." The first portion being the podcast the plaintiffs have named the 6-hour podcast. Okay, and the second podcast being the Jason podcast, right? March 19th, the next day, Jenn Kamp's email to counsel after confronted with the evidence. After confronted with the evidence that, and I expect the evidence has to do with this text message with Heidi Sharp saying that they did record it earlier this week in February of 2023. So March 19th, 2024, Kamp's email to counsel after confronted with evidence that actually she did record it. Jenn Kamp says, "When Jason and I decided not to post the podcast we recorded saying goodbye to the ex-Mormon community soon after recording it, noting the video had nothing to do with this case, John DeLynn, or the OSF, but for friends/listeners of ours in the ex-Mormon space, we deleted this video." Oh my gosh. So now it's gone from we never recorded it to we deleted the video. And finally, April 18th, 2024, in Kamp's opposition to the motion for order to show cause, she writes, again, the video was deleted by the recording studio online software when I stopped using their services. So as far as this Jason recording goes, here's the permutations, okay? February 16th, 2023, Jenn Kamp says that she and her husband, Jason, recorded that video earlier that week. January 30th, 2023, she says, "I don't even know if my husband and I ever actually recorded that." March 18th, 2024, Jenn Kamp says it was never recorded. March 19th, 2024, Jenn Kamp says, "We deleted this video." And April 18th, 2024, she says the video was deleted by the recording studio online software. That's how good Jenn Kamp is at keeping her story straight on why it is that she is never, ever, ever going to give to the plaintiffs this recording that she and her husband Jason did. Going back to the judge's order, these contradictory statements persuasively demonstrate that Ms. Kamp intentionally spoliated that recording, likely after the court ordered her to produce it, and that she has not been forthcoming with plaintiffs or the court. In the declaration, the court instructed her to file swearing that she had complied with the court's order. Ms. Kamp claimed that she did not produce the Jason recording because it had never been recorded. We've seen these now. They're going to go through the contents of that exhibit here in the order. The judge is going to reference it all. She expressly stated the second podcast was never recorded. She made the same claim in an email she sent to plaintiff's counsel on March 18th, 2024. This new position that the recording never existed was not only inconsistent with her prior positions, i.e., it had never been recorded, right? It never existed. That she was withholding the recording because it was private. Yeah, wait a second. I thought you were withholding the recording because it was private, not you were withholding it because it didn't exist, because you never recorded it. But also with other evidence it's inconsistent with. For example, Ms. Kamp referenced the recording in the February 16th, 2023 text stating that she recorded the podcast with Jason earlier that week and that she intended to release it the following day. Importantly, this text message was exchanged on February 16th, 2023. Ms. Kamp described the video podcast as responding to this lawsuit. So Ms. Kamp certainly was aware of this lawsuit filed on February 7th, 2023, when she made the recording, and it related to this lawsuit. When plaintiff's counsel reminded Ms. Kamp of the foregoing text exchange, Ms. Kamp changed her excuse for not producing the recording yet again. Ms. Kamp then claimed to plaintiff's counsel that she and Jason had deleted the recording. We deleted the video. This statement stands as a direct admission of intentional destruction of evidence and is in stark contrast to her previous claims of uncertainty about the recording's existence and her earlier claims that it was private. Plaintiffs filed this motion and sought sanctions for spoliation. In opposition to the motion, Ms. Kamp changed her story related to the Jason recording for a fourth time. Therein, she claimed that the recording was deleted by a subscription service where the video was allegedly recorded. She offers no explanation as to why the Jason recording is the only recording that was deleted, nor any information as to which software service she used in the recording, nor any evidence that the podcast had been deleted. Moreover, this statement cannot be reconciled with her prior statements that she was withholding the recording because it was private, that she did not know if she had ever even recorded the podcast, and that she and her husband had intentionally deleted the podcast. At the hearing, in an attempt, I think there should be an "and" there. At the hearing, in an attempt to explain the inconsistent and ever-changing nature of her excuse for not producing the Jason recording, Ms. Kamp claimed that plaintiff's counsel had misunderstood. You just didn't understand. Plaintiff's counsel had misunderstood what video Ms. Kamp had been referring to when she claimed that she had never even recorded the podcast. Okay, you've caught me, you've caught me, you've caught me. So obviously, you were wrong. You misunderstood. It wasn't that video. It was a different video. In response, plaintiffs presented Ms. Kamp's recorded statements during a meet and confer conference wherein Ms. Kamp specifically identifies the Jason recording and claims that she did not know if she ever recorded a podcast with Jason. This is where Jenn Kamp at the hearing is telling the judge, oh, they must have been mistaken. They must have misunderstood which podcast I was talking about. I wasn't talking about the Jason recording. When I said, I don't know if I actually even recorded it. Well, actually, it was. And she identified it as such. And that was the evidence they produced. Quote, I don't know if my husband and I ever actually recorded that. I don't know if my husband and I ever actually recorded that. This is the only podcast that involves her husband, Jason. It has to be the one she's referring to. She was caught red-handed, being disingenuous and lying to the court. This statement demonstrates unequivocally that Ms. Kamp had been discussing the Jason recordings when she told plaintiff's counsel and the court that she had never recorded the podcast. Ms. Kamp also argued at the hearing that OSF is not prejudiced by the deletion because the Jason recording had not been about this case. Just trust me. I'm not going to give you the recording. Even though I said it was recorded in one text message, it was either never recorded or I deleted it or the software deleted it. But anyway, it doesn't make any difference because it doesn't have anything to do with the case. Just trust me. This statement is especially concerning because if Ms. Kamp could not remember recording the podcast, how could she remember what it was about? Further, as the person who allowed such evidence to be spoliated, which she probably did herself, let's face it, she must bear the consequences of OSF now being incapable of testing the veracity of such assertion. Further, Ms. Kamp's own texts describe the video podcast as being a response to this lawsuit. Come on, Jen. In short, Ms. Kamp's representations and claims to the court in her filings and at the hearing were directly contradicted by her own words in text messages and during the meet and confer conference. Ms. Kamp's changing positions about why she has not produced the Jason recording, including positions she made in sworn statements to the court. That's called perjury, by the way. Her apparent lack of candor to the court and the evidence presented by plaintiffs demonstrate that Ms. Kamp intentionally spoliated the Jason recording after her duty to preserve arose, and likely after she was ordered to produce the recording. The duty to preserve arises when litigation is reasonably contemplated. It definitely arises when you get the preservation letter, and it certainly applies after that when the court has told you to produce the damn thing. The court is very concerned about Ms. Kamp's willingness to intentionally or recklessly make statements to the court that are untrue. This lack of candor raises significant concerns about whether Ms. Kamp has been truthful in her other pleadings, her sworn testimony in this case, and in her representations to the court and plaintiffs about the completeness of her discovery production. Next section, Ms. Kamp's spoliated text in the WACA group thread. In addition to the spoliation discussed above, plaintiffs also presented persuasive evidence at the hearing to show that Ms. Kamp spoliated text messages with the women in the WACA group texts. Many of the women in the text thread were OSF donors, and at least one had an interview scheduled with OSF that same month, the one that she canceled, along with her donation. Specifically, plaintiffs produced at the hearing the WACA group text thread that Ms. Kamp finally produced to them in March 2024, 2 months ago. And it was actually just a month before the hearing. In March 2024, months after fact discovery was closed, the thread shows a number of text messages indicating that they had been unsent by Ms. Kamp. The content of the text messages surrounding the unsent messages shows that Ms. Kamp made some statements about plaintiffs that resulted in the members of the text thread ceasing their donations to OSF, canceling their appearances on OSF, and otherwise expressing outrage against plaintiffs as a result of whatever text messages Jenn Kamp sent that she then unsent. At one point, Ms. Kamp thanks the Waka group for believing patterns, a phrase that Ms. Kamp has used in other contexts to assert that Mr. DeLynn had a pattern of sexually harassing 19 women over 12 years. Now, I'm going to go to that exhibit. So let's look at some of those. Okay, so here is Exhibit P. And here we have the text thread with the badass bitches. Jenn Kamp is one of this group. And here is a good example here in the middle screen grab where you can see on September 15th, 2022 at 8:57 p.m., Jenn had sent something out, but later on she went back and she deleted the message, or in other words, she unsent the message. It means deleted the message. It just shows up as unsent. So she got rid of whatever it was that she said in that before she disclosed it to the other party, because for some reason she didn't want the OSF attorneys to find out what it was she said here. She didn't want the jury to find out what she said here, and she didn't want the judge to find out what it was she said here because it was likely defamatory about John DeLynn and would have subjected her to a finding that she had indeed engaged in defamation. Okay, here's some more. Here's two text messages down here on September 16th, 2022. All of them by Jenn, by the way. Only Jenn unsends messages, I believe, in this. I could be mistaken, but she certainly has the lion's share of them if there are any others. So there's two that she unsends September 16th. In the middle, those are a replication of the same two. On September 16th, there is some replication. As you know, when you do screen grabs on text messages, you duplicate a little bit at the top and the bottom to make sure that you've got everything, and you can show that you've got everything. And here on, what day is this? September 20th, 2022, Jenn unsends a message. And then over here, there are three messages that Jenn deletes. There's another down here that says it's unavailable, that someone's replying to Jenn, and it says it's unavailable because it had been deleted. Let's see here, going through these, looking for red lines. Here's another one, September 21st, that Jenn unsent a message. Over here, September 23rd, Jenn unsends a message. Over here on the right, this is October 4th, it looks like, 2022. Oh, that's where they have it underlined, to believe me and believe patterns. That's where she's using the similar type of language that they had referred to, that the judge had referred to in his order that I just read. Oh, here is where Jenn now on the left, where you can see it, there's red underlining there, where Jenn is asking the others to supply her with a complete copy of this text thread, this group text thread that she's been a part of, because now she's claiming that she can't find them. She can't get them. So she needs somebody else in the group text thread to supply them to her because for some reason she can't get them off her own phone. She says, I would like them for myself. In other words, not for the judge, not because I'm required to do this in response to the request for production from plaintiffs and hand this over to them. She says, no, I would like them for myself. And down here, she gets more specific. She says, I would just like to have a copy from you all so that I have it. If I needed during discovery, if he claims things within them. Otherwise, this will always stay private as it should be. So here we have Jenn Kamp in the context of these messages. She actually should have deleted this one too, but she didn't think to. She's actually saying to the others that she needs a copy of everything just so that she will have it for herself, but she's going to keep it private and she's not going to produce it to the court or to the other side as she is supposed to do and required to do in response to their request for production and in response to the order of the court to produce this. Okay, so that is all of the text message thread, the Waka group text message thread. Let's go back to the order. What Ms. Kamp may have said to these women is especially important in this case because Ms. Kamp has since taken the position that she never told anyone that Mr. DeLynn sexually harassed 19 women over 12 years, and she admitted in sworn testimony that she did not even know or reach out to any of the women she claimed he had abused. And that was in her deposition. Ms. Kamp admitted at the hearing that she unsent the text messages and that they were not available from any source. She claims, however, that the deleted text messages were innocuous. That's why she deleted them, because they were innocuous. Not only is this not persuasive, given the text responding to whatever was said in the unsent messages, but as the party who deleted the texts, she must bear the consequences of such loss of clearly relevant evidence. So, for instance, back in this text message thread on September 16th, 2022, Donna says, "Does anyone know how to stop donating to Mormon stories? It comes out of my credit card automatically every month." Someone named Heidi put something up. Then Jenn Kamp sends 2 messages in sequence, which she later redacts. And in response to those messages, before they were redacted, Heather says, "That's what I did, and it worked. I hope you're doing okay, Jenn. I've been thinking a lot about you." So now Jenn allows this comment that she made to stand. "Thanks, Heather. It's been a roller coaster of emotions, etc." But why is it that in response, seemingly, to these 2 text messages that Jenn has deleted, Heather then talks about, "That's what I did and it worked," i.e., stopping donations to Mormon stories, which is a critical issue in this case, isn't it? And why it was that these women were stopping their donations based upon what Jenn Kamp had told them, doubtless in the text in this thread that Jenn Kamp later went back and deleted so it wouldn't be available as evidence against her in the civil case. Going on with the order, the Waka group texts also show that Ms. Kamp was an active participant in the text thread in June 2023. This date is remarkable because it was just 2 weeks before Ms. Kamp served her responses to discovery, wherein she does not identify this text thread even though it is plainly responsive. This would be fresh on her mind as of the time she has to respond to the request for discovery, but she doesn't include it. She doesn't even mention it, even though she's required by the terms of the request for discovery to include it or at least mention it, even if she can't get the texts themselves. No, she's hiding it completely from the other side and hoping they will be none the wiser. Ms. Kamp later claimed that she did not produce the Waka group text because it was encrypted. It is not believable that Ms. Kamp did not have access to any part of the Waka group texts, given her continued participation in the text through at least June 11th, 2023. This claim seems to represent a pattern Ms. Kamp has shown of blaming technology when she is caught withholding or destroying evidence. Oh, yeah. Furthermore, encryption does not explain why Ms. Kamp did not identify and describe it or any communications with any of the Waka group texts in her initial responses to discovery. Ms. Kamp had an obligation to produce any part of the text that she had access to identify and describe the communications that she had that were not reflected in produced documents, and to explain at that time that the text thread was not available and why. She did none of those things. This is especially concerning given that shortly before her discovery responses were due, she was specifically discussing on the Waka group text that she would not produce that text thread. She tells the women, "I would just like to have a copy from you all so that I have it if needed during discovery if he claims things within them. Otherwise, this will always stay private, as it should be." This demonstrates explicit intent to withhold evidence that Ms. Kamp then concealed. It's not just she's saying it and then she produces it. No, she's saying it and then she conceals it and lies about it. The Waka group texts also reveal the dishonesty of other statements made by Ms. Kamp. For example, the woman who Ms. Kamp earlier told plaintiffs had donated $50 to Ms. Kamp, but which Ms. Kamp claimed had nothing to do with this case. She was a member of the Waka group texts and part of the discussion therein about how to cancel donations to OSF. Right, Jen, it had nothing to do with this case at all. Ms. Kamp's efforts to conceal the very existence of the Waka group texts, combined with the numerous deletions of Ms. Kamp's messages within the group, suggests that Ms. Kamp was aware that the evidence contained in the thread would be harmful to her position and strategically chose not to produce it or to take measures to preserve it. Unsend, unsend, unsend. Importantly, all of the unsent messages occurred on or after September 15th, 2022. You remember why that's important, right? Because of the preservation letter. That is the date that Ms. Kamp's counsel sent a demand letter to plaintiffs and the parties first exchanged correspondence about their preserved obligations. At the hearing, Ms. Kamp argued that you can only unsend Facebook messages within 10 minutes of them being sent. Do you remember her saying that? Did you listen to that? Even people in the live chat were going back and they were unsending messages that were much older than 10 minutes old, weeks old, months old. It doesn't make any difference how old it is. You can unsend it. Go try it yourself. She was just making stuff up. This does not appear to be an accurate statement, which itself might be the understatement of the year. This does not appear to be an accurate statement. The Waka group texts themselves show women responding to Ms. Kamp's messages that were later unsent much later than 10 minutes later. In other words, you've got an unsent thing from Jenn Kamp that's sent at one point in time, right? And then 12 hours later, you have another member of the group responding to what Jenn Kamp said. But now Jenn Kamp's text is unsent. So how does a member of the group respond to a text that Jenn Kamp sent 12 hours before, unless it's still there? It hasn't been unsent yet. Jenn Kamp had to unsend that message more than 12 hours later, because 12 hours later, there's another person in the thread who's responding to the message that she unsent. So obviously you can unsend these messages after more than 10 minutes, indeed, after more than 12 hours, as proved within the text thread itself. Even if this claim were true, however, each of the texts was unsent after September 15th, 2022, when there was a reasonable likelihood of litigation and after Ms. Kamp was made aware of her preservation obligation. Now, after the findings of fact, we go to the conclusions of law. The court has broad authority to impose sanctions for violations of its orders, for failing to cooperate in discovery, for spoliating evidence, and for otherwise engaging in efforts to frustrate the judicial process and undermine the authority of the court. Then there's some language from other cited cases that supports that statement. I'm not going to read through those. Here, sanctions are appropriate because Ms. Kamp has repeatedly, willfully violated the orders of this court and refused to accept the authority of the court in an attempt to hide, destroy, or conceal evidence relevant to this case and to frustrate the discovery process to the detriment of plaintiffs. Sanctions are also appropriate because Ms. Kamp engaged in persistent dilatory tactics. Dilatory is a word that means the opposite of timely. In other words, she's hanging back and she's being slow, she's being late in everything she's doing. Persistent dilatory tactics intended to frustrate the judicial process. She was slow rolling it. Sanctions are further appropriate because Ms. Kamp has concealed the existence of and destroyed or allowed to be destroyed significant evidence after her duty to preserve arose, in some instances after it was requested, and likely after she was ordered by the court to produce it. Under Utah law, a party has a duty to preserve evidence and prevent its deletion when litigation is pending or reasonably foreseeable. Even inadvertent destruction of potentially relevant evidence or evidence likely to lead to the discovery of relevant evidence after a duty to preserve arises can justify dismissal because of the resulting unfairness to the other party. This is what happens when you play games, Jen. You decided that you were going to play games, you were going to hide evidence, you were going to delete evidence, you were going to lie to the court, you were going to lie to the other side to hide all this evidence. Then when you got caught hiding evidence and deleting evidence, you changed your story many, many times in order to try and justify why it was that you weren't providing it. Eventually, after multiple warnings by the court, you finally find yourself in this position, which is where the judge says, I've had it. You have acted in such a way, Jen, as the defendant, that you have made it impossible for the plaintiffs to have a fair trial because you've been destroying as much evidence as you possibly can that would show you're guilty, obviously, and therefore the judge is going to find in this order as a matter of fact that you committed defamation against John Dehlin. There's not going to be a jury trial. You're not going to get away with this. You defamed John Dehlin, and all we're going to decide now is how much you're going to owe him, what the damages are for the defamation you did, in addition to attorney's fees. We'll get to that too in a second. A party should not be deprived of the opportunity to pursue their claims based on factors unrelated to the merits of the case. In other words, the discretion to impose sanctions for reckless or negligent spoliation remains as broad as the discretion which is accorded for the imposition of sanctions where the conduct was deliberate and intentional. In other words, it doesn't make it any less prejudicial to the plaintiffs why it is that you destroyed evidence. If you destroyed it intentionally, yeah, that's worse. But if you destroyed it negligently, it doesn't affect the plaintiffs. They still don't have the evidence. And if you negligently, recklessly, or deliberately and intentionally, which is what you did, Jen, destroy evidence, this is what's going to happen to you. You're not going to be able to get away with this. And this is the judge telling you that you didn't get away with it. And he's telling it to you in writing. For both inadvertent and intentional destruction of evidence, the court must impose a sanction that best serves the dual purpose of ameliorating the harm caused to the opposing party by the destruction of evidence and punishing the party who had custody of the documents severely enough to deter future spoliation by them or others in the future. Under this test, even inadvertent spoliation can lead to terminating sanctions if the evidence that was destroyed was likely important to the opposing party's case. Terminating sanctions are especially appropriate where a party has attempted to improperly influence the court's decision on the merits of the case through destruction of evidence, obstruction of justice, or other conduct that itself tends to demonstrate bad faith or lack of merit. Where destruction appears intentional or reckless, the court may presume that the destruction is an admission of want of merit in the asserted defense. In other words, your defense doesn't have any merit. Otherwise, you wouldn't have to destroy evidence that contradicts it. In those circumstances, such intentional efforts to frustrate the judicial process should result in serious sanctions, including striking the pleadings and entering default judgment against the destroying party, which is what's going to happen to you, Jen, at the end of this order. Actions which are found to be deliberate and purposeful ought to be punished accordingly. Ms. Kamp's duty to preserve evidence and prevent its deletion arose at the latest on September 15, 2022, when her counsel threatened litigation and the parties first exchanged preservation communications. At that point, litigation was reasonably anticipated, and any destruction of evidence in Ms. Kamp's control, whether intentional or inadvertent, is sanctionable. Although Ms. Kamp has not provided any credible evidence about the dates upon which any of the spoliated evidence was deleted, because all of those communications or recordings were created after September 15th, 2022, Ms. Kamp's spoliation of the text in the Waka group texts of the Jason recording and of the comments on her social media videos about plaintiffs all occurred after her duty to preserve arose. Applying the foregoing legal principles to the facts present here, terminating sanctions and an award of attorney's fees are warranted. Ms. Kamp's continued violations of the court's discovery and other orders and refusal to accept the rulings of this court, even after being warned that sanctions may be entered if she does not comply, make it likely that she will continue to violate the court's orders and act in a manner contrary to the authority of the court. Additionally, lesser sanctions are unlikely to ameliorate the harm to plaintiffs. The nature of the evidence that was spoliated, i.e., that Jenn deleted, and the likelihood that other relevant evidence has been concealed, withheld, or spoliated warrants the imposition of terminating sanctions. These are the most severe sanctions that could be issued by the judge, and that's what he's doing. This case is over, Jen. For example, the nature of two categories of statements that we know were spoliated, Ms. Kamp's recording with her husband, Jason Kamp, and her text with a group of OSF donors, are all significant to the claims of defamation in this case and could not be adequately conveyed through an adverse inference. What they mean by an adverse inference is if they have a jury trial and say, look, this was spoliated, and they allow the jury then to draw an inference that if Jenn spoliated this evidence, then it probably has negative stuff in it or defamatory stuff in it about John Dehlin, and that's why she deleted it. But what they're saying is, no, That's not good enough. It's not good enough to go to a jury trial and just tell the jury, well, there's deletion of stuff, and so you can infer it was defamatory. That has one impact. It's a lesser impact. It's a good impact for OSF, but it's not as good as actually being able to present what it was she said to these people. And that's why they are asking for and getting terminating sanctions from Judge Faust. The unsent text from the Waka group text, if not spoliated, would show in Ms. Kamp's own words the statements she was making in private conversations to OSF donors about John DeLynn. An adverse inference to the jury that Ms. Kamp defamed Mr. DeLynn to OSF donors could never adequately convey to the jury the impact of those harmful comments. In other words, if a jury were to assess damages against Ms. Kamp for defamation, its award based on an adverse inference that Ms. Kamp defamed Mr. DeLynn would likely be significantly less than if the jury could see that Ms. Kamp falsely stated, for example, that Mr. DeLynn had forced her to watch a pornographic video at work, made sexual advances towards her, and sexually and physically abused her and 19 other women over 12 years. The Jason recording and the Waka group texts are important pieces of evidence in this case, as they likely provide concrete examples of the types of defamatory claims that Ms. Kamp was making against DeLynn and OSF to donors and to the general public. Furthermore, the Waka group texts and Jason recording could also contain statements by Ms. Kamp that are inconsistent with her characterization of plaintiffs in her defamatory statements. In other words, not only would it provide the actual defamatory statements that she made, but it would also provide additional statements by her that could be used for impeachment purposes if indeed they were contradictive of earlier statements that Jenn Kamp had made. Those prior inconsistent statements would cast doubt on Ms. Kamp's claims that her statements were truthful and also show that she acted with malice necessary to award punitive damages. There is no jury instruction that could adequately ameliorate the loss of such evidence to plaintiffs. Now, by the way, this is going to be interesting when they get to the damages section, because if she acted with malice, and I think there's a lot of evidence here that she did act with malice. In fact, I don't think the judge would be signing this order terminating the case with terminating sanctions unless he thought she had acted with actual malice. But at the one hearing that's left in this case, the damages hearing where the judge is going to assess damages, if he finds that Ms. Kamp acted with malice in deleting this evidence, in spoliating this evidence, then that can serve as an award for punitive damage. In the law, there are two main kinds of damages. There are general damages, which are supposed to compensate you for damages that you suffered from somebody else. But there are also punitive damages, which are on top of general damages. And punitive damages have to do with punishing the party who did something that was so wrong that it deserves to be punished with extra damages. And those are punitive damages. And significantly, punitive damages, I believe, cannot be discharged in bankruptcy. I could be mistaken about that. I've never done bankruptcy law. I talk to other attorneys who do. That's my understanding. Let me know in the comments if that's correct or if you have a different take on that. But general damages can be discharged in bankruptcy. Punitive damages, I don't think they can. So that could be very significant when it comes to the time for the damages hearing and how the judge is going to frame those damages as general and punitive. There is no jury instruction that could adequately ameliorate the loss of such evidence to plaintiffs. In short, even if Ms. Kamp's spoliation were inadvertent, it would be unfair to force plaintiffs to suffer the prejudice caused by her spoliation when clearly relevant evidence was lost through no fault of plaintiffs. As the party with the duty to preserve, Ms. Kamp must bear the consequences of such loss. The loss of this evidence severely prejudices plaintiffs and hinders their ability to have a fair trial on the merits to such a degree that lesser sanctions cannot adequately ameliorate the harm to them. Furthermore, the court is persuaded that Ms. Kamp's spoliation was not inadvertent. Paragraph 93, that's huge. Furthermore, the court is persuaded that Ms. Kamp's spoliation was not inadvertent. In other words, it was intentional. In other words, there was malice. In other words, there could be punitive damages coming down the pike for Jenn Kamp. The following events, which occurred prior to or close in time to the destruction or withholding of evidence, strongly suggest that Ms. Kamp's spoliation and concealment were intentional. A, the initial preservation letter exchanged on September 15th, 2022 occurred before any of the evidence was deleted. Importantly, many of the unsent texts were created on or around September 15th, 2022, suggesting that Ms. Kamp went back and deleted these texts after understanding that her communications may be discoverable, or at a minimum, after she threatened litigation and her preservation obligation arose. B. Plaintiffs reminded Ms. Kamp of her preservation obligation in a letter dated October 28, 2022, in which they told Ms. Kamp that they believe she was deleting comments from her social media posts in violation of her preservation obligations and specifically requesting that she keep all communications and comments. This was only 6 days after Ms. Kamp's first social media post and predates by approximately 54 days the date upon which any comment should have been auto-deleted, and by at least 3 months the dates upon which Ms. Kamp claims that the Jason recording and some of her text messages in the Waka group text were created and subsequently deleted. In other words, what this paragraph is saying is that Ms. Kamp knew perfectly well that she had a duty to preserve the evidence when she was going about willy-nilly deleting evidence like some kind of malicious Billy Burke. Going on, C. Ms. Kamp filed a lawsuit against plaintiff John DeLynn in federal court on January 17th, 2023, and posted a video about it on January 28th, 2023. At that point, litigation was active, not just reasonably anticipated. She knew she couldn't be deleting evidence. Again, this predated the creation of the Jason recording by at least a few weeks. That was in February of 2023, and was at least 60 days before the comments on that social media post disappeared. Despite this active duty to preserve, Ms. Kamp deleted or allowed to be deleted the recording, social media comments, and text from the Waka group text. All of this is being done in order to demonstrate that these were not just things that were deleted before any litigation was contemplated or before Jenn Kamp knew about her duty to preserve these pieces of evidence. They were done well after she knew about all that. Therefore, her deletion of these is not accidental. This is the evidence that shows it was intentional. Plaintiffs filed this lawsuit and served it on Ms. Kamp in early February 2023. This is close in time to when the Jason recording responding to this lawsuit was made and to when the comments on Ms. Kamp's January podcast about plaintiffs were still available. Ms. Kamp allowed those items to be deleted, even after plaintiffs have served her with a lawsuit, even after she had served a lawsuit on the plaintiffs, remember, in federal court, the one that was dismissed because she filed it in the wrong court. But obviously, if she files it, even if it's in the wrong court, Jenn Kamp knows that litigation is pending because she's already started it. And it's even after the letters were exchanged between attorneys saying to preserve the evidence, preserve the evidence, preserve the evidence. Jenn Kamp did not take any of those things seriously. And she acted in direct contradiction to them. And she acted in direct contradiction to court orders, which is going to be coming up next, which shows beyond any reasonable doubt that she was acting intentionally and maliciously in deleting this evidence. E. Plaintiff served written discovery requests on Ms. Kamp on May 19th, 2023, and she served her responses on June 23rd, 2023. This was close in time to when Ms. Kamp was active in the Waka group text and explicitly told the participants that she would not produce that text thread unless forced to do so. She did not identify, produce, or indicate the inadvertent deletion of any of the recordings, comments, or Waka group text thread in her responses to discovery. She's hiding it. The court ordered Ms. Kamp to produce the Jason recording on March 8th, 2024. Prior to that date, Ms. Kamp opposed producing such recording on the grounds that it was private. After the court's order, she then claimed she and her husband had never recorded it or later deleted it. Remember those changing stories, Exhibit W? After this current motion, she claimed the software program deleted it. Yes, the dog ate my homework. Because Ms. Kamp spoliated the foregoing evidence, the court may presume that each item that she destroyed or allowed to be destroyed would have been harmful to her position. Of course, that's why she's deleting it all. This presumption is bolstered by Ms. Kamp's attempts to hide the very existence of such evidence and by other texts and documents referencing or responding to the spoliated documents. For example, the text surrounding the unsent texts in the Waka group text suggests that Ms. Kamp was making defamatory statements about plaintiffs that caused the recipients of that text to discontinue their donations to OSF, to cancel their interviews with OSF, and to express concern for Ms. Kamp and outrage at plaintiffs for whatever Ms. Kamp said in the deleted text messages. Ms. Kamp concealed the very existence of such evidence and then has presented ever-changing stories about why she cannot produce the evidence. These stories are not consistent and suggest a lack of candor with the court and plaintiffs. For this additional reason, lesser sanctions cannot ameliorate the harm to plaintiffs. Ms. Kamp's concealment of clearly relevant evidence that was only discovered by plaintiffs because it was referenced in other documents suggests that Ms. Kamp has likely concealed the existence of other relevant evidence that plaintiffs will never know about and spoliated other evidence that was harmful to her position. The loss of this evidence and likelihood that other evidence has not been disclosed severely prejudices plaintiffs and hinders their ability to have a fair trial on the merits to such a degree that lesser sanctions cannot adequately ameliorate the harm caused by Ms. Kamp's conduct. As the court noted during the hearing, many of Ms. Kamp's statements to the court lacked candor and were inconsistent with the evidence and Ms. Kamp's prior statements to the court. This lack of candor raises significant concerns about whether Ms. Kamp has been truthful in her other pleadings, her sworn testimony in this case, and in her representations to the court and plaintiffs about the completeness of her discovery production. In other words, if there's all these places where we've caught her lying and hiding stuff, how many places has she lied and hidden stuff where we didn't catch her? That's what's being raised here. Indeed, at the hearing, April 23rd, plaintiffs presented evidence indicating that Ms. Kamp perjured herself during her deposition. In the deposition, Ms. Kamp testified that she could not recall what video Mr. DeLynn had asked her to watch and denied telling anyone it was Joe Sarah's sexually explicit and pornographic music video. Ms. Kamp also claimed that she didn't know why her attorney claimed in the September 15th demand letter that Mr. DeLynn had forced her to watch that video and stated that she had not told her attorney about that video. No, her attorney just came up with it out of his own mind. She never told him about that. However, plaintiffs presented an email from Ms. Kamp to her counsel with the Joe Sarah video attached and the subject line from Jenn, music video John had me watch until I walked away. So here's what's going on. Jenn Kamp falsely claimed to her attorney at the time, this would be September of 2022, that John DeLynn had made her watch a pornographic music video. She sent a link to the video by email to her attorney, and she titled it Music Video John Had Me Watch Until I Walked Away. Based upon that email, her attorney included in his demand letter to John DeLynn and OSF in September of 2022 a reference to this exact same video. Why? Because Jenn Kamp had told him this was the one. As with her other stories, that story ended up devolving because actually that wasn't true at all. John had never shown her that video. She knew that was the case. She knew this was a lie. And so now that she had been caught in this lie, she starts backing away from that position in her deposition and saying she could not recall what video Mr. DeLynn had asked her to watch. And she denied telling anyone it was Joe Sarah's sexually explicit and pornographic music video. And then she gets caught in the lie because then they have the email from Jenn Kamp to her attorney sending him that very same video and identifying it as the music video John had me watch until I walked away. Ms. Kamp's deposition testimony disowning the accusations in her demand letter underscores the significance of the Waka Group texts. The accusations in the demand letter, which was sent to the plaintiffs around the same time as the now spoliated messages, might likely appear in the Waka text thread had Ms. Kamp not destroyed those messages. Any statements Ms. Kamp made to the Waka Group about any video she claimed John DeLynn made her watch would either show her defamation of Mr. DeLynn or further perjury now. It would either show that she was defaming John DeLynn or it would further perjure Jenn Kamp, show she's lying, or actually it could do both. Similarly, in her deposition testimony, Ms. Kamp denies ever telling anyone that Mr. DeLynn sexually harassed her and 19 other women over the course of 12 years. The loss of the Jason recording and Waka Group texts are detrimental to plaintiff's case because they are likely to have contained explicit statements that Ms. Kamp now denies ever making. Oh, you bet they do. Having viewed the evidence and witnessed Ms. Kamp's demeanor and lack of candor with the court is persuaded that Ms. Kamp's conduct is not inadvertent. Allowing a party to continually flout the authority of the court and engage in conduct that, if left unchecked, would call into question that fairness of the judicial system and would undermine and erode the public confidence in this court and the judicial system in its entirety as well as severely prejudiced plaintiffs. Attorney's fees for the plaintiff's efforts to obtain the concealed evidence are also appropriate. Plaintiffs have expended significant sums trying to obtain evidence that Ms. Kamp actively concealed and then spoliated. Had Ms. Kamp disclosed the existence of the evidence and produced it when obligated to do so, or if it was already spoliated, disclose such fact at the outset, plaintiffs would have avoided these costs. Attorney's fees are not available under the claims plaintiffs asserted against Ms. Kamp. Now, what that means is there are certain civil actions that the statute provides that if you prevail, you can also get your attorney's fees from the other side. That's the exception, not the rule. It has to be specifically stated in the statute. This is not one of those. So the claims against Jenn Kamp by OSF do not have an attorney's fees provision. They're going to have to pay for their own attorney's fees for the bringing of the case. But in a situation like this, where the other side, Jenn Kamp, has, by her actions, required these attorneys to work much longer and much harder and bill a lot more to OSF and John DeLynn, it is not fair that OSF should have to pay those fees to their attorneys for doing work that was caused only because of Jenn Kamp hiding stuff and lying about it. And this is what the judge is going to say now. The judge is going to say, that's not right. Therefore, in addition to the $12,000 in attorney's fees that have already been assessed against Jenn Kamp for this kind of stuff in the past, we're going to add on top of that all attorney's fees that were charged by OSF's attorneys that were required to be charged only because they had to keep going after Jenn Kamp and trying to get her to comply with her obligations, her legal obligations, and to get her to follow the orders of the court. So paragraph 106 starts with, attorney's fees are not available under the claims plaintiffs asserted against Ms. Kamp. Accordingly, plaintiffs should not be forced to bear the costs of the repeated motions to compel Ms. Kamp to cooperate in discovery and comply with the court's orders, which would have been unnecessary if Ms. Kamp had complied with her obligations under the Utah Rules of Civil Procedure and been candid with plaintiffs and the court at the outset. For example, if Ms. Kamp had disclosed that she deleted the JSON recording in her initial responses to discovery, plaintiffs could have sought spoliation sanctions at that time, instead of having multiple meet and confer conferences, filing 2 statements of discovery issues, filing a second request for discovery, seeking the specific recordings instead of all recordings, and filing a motion for order to show cause. See all this extra work that she caused by lying and hiding stuff? Similarly, if Ms. Kamp had complied with her obligation to produce bank statements in response to her written discovery, instead of saying that she had received no money, plaintiffs would not have had to engage in multiple meet and confer conferences, file a second request for written discovery, ask for the documents at her deposition, file 2 SODIs, statement of discovery issues, or file a motion for order to show cause asking the court to enforce its orders. Ms. Kamp's unfair concealment and withholding significantly increased the amount of work and thus attorney's fees plaintiffs incurred in attempting to obtain the evidence. Consistent with the foregoing, the court hereby orders that Ms. Kamp's answer and affirmative defenses be stricken and that judgment be entered in plaintiff's favor on all claims. All the claims that OSF and John DeLynn have made against Jenn Kamp, they just won by virtue of this order. That judgment be entered in plaintiff's favor on all claims. The court shall hold an evidentiary hearing to determine the amount of damages to award plaintiffs. Plaintiffs may submit an affidavit in support of their attorney's fees amount to the court within 14 days of this court's order, which fees amount will be considered and set at the evidentiary hearing. It is so ordered. The court's signature is affixed to the upper right-hand corner of this document, and that is the end of the order. This last page here just being blank. And you see up here at the top of the order, there it says, signed, Robert Faust, District Court Judge, order of this court dated May 15th, 2024 at 12:25 p.m. So what that means is at the hearing, which I'm going to guess is going to be when the trial was originally scheduled in August of this year, it'll be a couple of months out, that at that hearing, the judge is going to already have $12,000 in attorney's fees that have been ordered against Jenn Kamp for these kind of shenanigans. There's going to be an additional order, which is going to be much larger of attorney's fees for all the extra work that John DeLynn's attorneys have had to do in order to try and get Jenn Kamp to comply with her obligations under the law in discovering evidence to them. And number three, there's going to be a hearing about how much in general damages Jenn Kamp owes John DeLynn and OSF for the defamation that she has already been found to have committed against them. And we'll see if any of those damages are punitive damages, which, according to my understanding, cannot be discharged in bankruptcy. So that is the news here. It's been a big news day. And that is about all for tonight. Thanks for watching. Please hit like, please hit subscribe. I'll keep you apprised of any developments as they occur. Until next time, this is Radio Free Mormon, signing off the air.